Well, it looks like the courts are finally starting to catch up with the government power grab. Viva Frei, Montreal litigator turned YouTuber, and as you can see by the attire, it is officially winter in Canada, and the car vlogs are going to start getting a lot colder. I actually don't know exactly what I'm going to do in the dead of winter, but we will cross that bridge when we get to it. First and foremost, I should make two big announcements. As some of you may or may not know, I have also been posting my content to a website called rumble.com. It's sort of like a smaller YouTube without the politics, without the chicanery, and, sort of censorship-free content. I've been putting my stuff up there. Go check it out. It's rumble.com/Viva Frei or whatever. That's my account on Rumble. The other big news is that Robert Barnes and I have opened up a Locals community. Locals is that website founded by Dave Rubin, and we started a Viva Barnes Law community. Within Locals, it is a subscription-based community, but it's like $5 a month. So if you want to support the channel, get exclusive content, go to Locals. It is vivabarneslaw.locals. Whatever. Links are in the pinned comment. Now, getting to today's vlog, because it's a good one, the courts are finally starting to hand it to California's Governor, Gavin Newsom. Yesterday, I received a bunch of emails from people telling me I have to absolutely cover this decision coming out of California. Governor Gavin Newsom is finally having his tushy handed to him by the courts, and I saw the decision. It's a very interesting decision. It was a petition for declaratory relief and injunctive relief. The underlying essence of the lawsuit is that Governor Gavin Newsom far exceeded his authority as governor and basically issued unconstitutional executive orders which violated the separation of powers between the judicial, the executive, and the legislative branches. It's a good, thoughtful decision, but knowing the way politics ruins everything, we have to go look at the judge to see if there might be some political explanation for why the judge issued the judgment. The judge is one Sarah H. Heckman, and an important thing to know is that this judge was not appointed, this judge was elected. Sarah Heckman is a judge on the Superior Court of Sutter County in California. She was elected to the court in 2012 to a term expiring in January 2019. Education. Heckman received her undergraduate degree from the University of California, Berkeley, and her JD from McGeorge School of Law. Career. Prior to joining the court, Heckman was the family law facilitator and directly of family court services for the Superior Court of Sutter County. Previously, she was a deputy district attorney in Sutter County and managing attorney for the Superior Court. Heckman received the most votes in the primary election on June 5, winning 26.03%. Because no one received more than 50% of the vote, she and Judd Wagaman competed in a general election. Heckman won election on November 6, winning 62.79% of the vote. All right, now that you know your judge, you can come to whatever conclusions you want based on political affiliations. So as to explain the decision, let's just jump into the decision to see what it says, because it is actually fascinating. James Gallagher and Kevin Kiley, plaintiffs, versus Gavin Newsom in his official capacity as governor of the state of California, defendant. Tentative decision following court trial. Two important details to point out already. The plaintiffs are apparently assemblymen in California, and what is a tentative decision? Well, it's described in the last paragraph of the decision. This tentative decision is the court's proposed statement of decision and will become the statement of decision unless, within 10 days after service of this tentative decision, a party specifies those principal controverted issues as to which the party is requesting a statement of decision or makes proposals not included in the tentative decision in accordance with California Rules of Court Rule 3.1590. C4. The clerk shall mail a copy of this tentative decision to all counsel and parties forthwith. This is very interesting because, to the best of my knowledge, we don't have tentative decisions in Quebec, but what it seems to be is the tentative decision is basically notifying the parties this will be the final decision unless within a period of 10 days you notify us as to what you take issue with in this tentative decision for potential reconsideration. It seems to be something of a pre-appeal before the same judge, before the decision becomes final in front of that judge. Seems like something of a motion to reconsider, as we saw in the Nicholas Salmon lawsuit. Bottom line, this is a tentative decision. It will become formal if, after 10 days, none of the parties notify the judge of any issues they take issue with in the tentative decision. Now let's see the tentative decision itself. This cause came on regularly for court trial on October 21, 2020. The parties introduced documentary evidence pursuant to stipulations set forth in plaintiffs' and defendants' statement of evidence and exhibits filed October 16, 2020. No witnesses were called. The cause was argued and submitted for decision. The court, having considered the evidence and the arguments of counsel, issues the following tentative decision. That is fancy judicial talk for we had a trial, evidence was presented, and the judge is coming to the decision she is coming to based on the evidence and arguments provided. Now, the decision itself can be broken down into three broad categories. Are certain elements of the decision moot for reasons which we are going to see? Were the executive orders unconstitutional for reasons we are going to see? And can the court issue the relief being requested for reasons that we're going to see? And the court comes to the conclusions that certain issues are not moot for reasons reasons which we have similarly seen in the governor of Pennsylvania lawsuit or Michigan, I forget which, but we're going to come to the conclusion that the issues are not moot simply because they are not in force or in effect now. Now let's read why. On the issue of whether the cause is moot, the court finds the cause is not moot. There are two distinct reasons for finding the cause is not moot. First and foremost, the legal controversy for which plaintiffs have requested declaratory relief is not limited to the validity of Executive Order N-6720, which concerns only the 2020 general election. The controversy at issue in this case is broader, specifically whether the governor has the authority under the California Emergency Services Act to exercise legislative powers by unilaterally amending, altering, or changing existing statutory law or making new statutory law. Plaintiffs take the position in these proceedings the governor does not have such authority under the California Constitution or the CESA to legislate by unilaterally amending existing statutory law. The governor takes the position that the CESA's grant of authority to exercise, quote, all police power vested in the state, end quote, allowing him to, quote, promulgate, issue, and enforce such orders and regulation as he deems necessary, end quote, authorizes him to legislate by unilaterally amending existing statutory law. This is the bottom line of the lawsuit. California has an act called the California Emergency Services Act, which authorizes the governor to implement certain regulations in the event of an emergency. Governor Newsom has interpreted the CESA as granting him the authority to amend existing statutory law or make new statutory law bypassing the legislature. And the judge comes to the seemingly logical conclusion that this type of conduct is forbidden on the wording of the law itself. Not only is this an active and ongoing controversy between the parties, but it is a critically important one for the judicial branch to resolve. The state of emergency brought about by the COVID-19 pandemic, which was proclaimed by the governor on March 4, 2020, continues in effect indefinitely, and the governor continues to have authority to act under the CESA. The governor has issued 3 executive orders during the current state of emergency, specifically regarding the November 3rd, 2020 general election, and has issued more than 50 different executive orders changing numerous California statutes since the state of emergency was declared. Further, despite representations by the governor's legal counsel that Executive Order N-6720 dated June 3, 2020 is, quote, withdrawn, end quote, there is no evidence it has been formally rescinded, and the executive order includes provisions controlling the election process for the November 3, 2020 general election, which were not superseded by the subsequently enacted legislation. This is effectively the identical argument that was raised in the Pennsylvania decision, where the governor said, look, we're not enforcing any of these executive orders, so the question is moot as to their legality, and the judge says no. These executive orders are sort of hanging over everybody's head like a sword of Damocles. They can be reinstated at the will of the government, so we need to determine whether or not they are valid. The plaintiffs had raised the argument that the CESA was unconstitutional in its nature given the powers it gave to the governor, but the court comes to the conclusion that the CESA is not in and of itself unconstitutional. That being said, the plain wording of the law is such that it confirms that what Governor Newsom is doing is in fact not authorized under the law. The plain language of Section 8567 only allows the governor to, quote, make, amend, and rescind orders and regulations. Clearly, the legislature understands the distinction between an order or regulation on the one hand and a statute on the other. Section 8567 does not empower the governor to make or amend statutes. The plain language of Section 8571 empowers the governor to, quote, suspend any regulatory statute or statute prescribing the procedure for conduct of state business or the orders, rules, or regulations of any state agency, end quote. The term, quote, statute is used in this section, but the section only authorizes the governor to suspend certain statutes, not to amend any statutes or create new ones. Finally, Section 8627 gives the governor authority over state agencies and in connection therewith to exercise all, quote, police powers vested in the state by the Constitution and laws of California. In qualifying this authority, Section 8627 further states that the governor, quote, shall promulgate, issue, and enforce such orders and regulation as he deems necessary in accordance with the provisions of Section 8567, end quote. Section 8627 does not empower a governor to make or amend statutory law by its own language and by specifying that the powers shall be exercised in accordance with Section 8567. The court has been provided no authority interpreting the phrase, quote, police powers as used in Section 8627, and the court does not interpret, quote, police powers in a manner which violates the separation of powers under the California Constitution. The Constitution gives the legislative branch the exclusive authority to make law and the executive executive branch the power to see that the law is faithfully executed. I will flash a screenshot of those 3 sections in case you want to read them for your own personal edification, but the bottom line, the judge came to the conclusion that those 3 articles of the CESA did not empower the governor to amend statutes. They did not empower Governor Newsom to amend or create new statutes, and in doing so by way of his executive orders, he exceeded the power granted to him under the CESA, you know what I mean. We then get into the question as to whether or not the plaintiffs are entitled to declaratory and injunctive relief, and the judge says yes, they are, and here's why. On the issue of whether plaintiffs are entitled to declaratory relief, the court's decision is plaintiffs are entitled to declaratory relief. An actual controversy exists relating to the legal rights and duties of the parties under the CESA and the California Constitution. It is the court's determination that a declaration pursuant to Code of Civil Procedure Section 1060 is necessary and proper at this time to provide certainty as to the correct interpretation of Sections 8567, 8571, and 8627 of the CESA, not only to identify Executive Order N6720 specifically as unconstitutional, but also to void further violations of the CESA and the California Constitution during the ongoing state of emergency by clarifying that the CESA does not give the governor the power or authority to amend statutory law or create new statutory law even during a state of emergency. On the controversy of whether or not the CESA allows the governor to amend statutory law or create new statutory law, the parties' positions are diametrically opposed, and the controversy is one of widespread public interest which deserves the consideration of the judicial branch. The court finds and declares Executive Order N6720 issued by the governor on June 3, 2020 is void as an unconstitutional exercise of legislative power and shall be of no further force or effect. The California Emergency Services Act does not authorize or empower the governor of the state of California to amend statutory law or make new statutory law, which is exclusively a legislative function not delegated to the governor under the CESA. You can't mince your words any less than that. And now on to the question of injunctive relief. On the issue of whether plaintiffs are entitled to injunctive relief, the court's decision is injunctive relief is proper in this case. Permanent injunctive relief may be granted pursuant to Code of Civil Procedure Section 526 when plaintiff is entitled to the relief demanded and which consists, at least in part, in restraining the commission or continuance of the act complained of, when pecuniary compensation would not afford adequate relief, or where the restraint is necessary to prevent a multiplicity of judicial proceedings. And to further justify the injunctive relief that the judge is about to grant, the judge goes on to write as follows. The state of emergency proclaimed on March 4, 2020 due to the COVID-19 pandemic continues with no end date in sight. The amendments to the elections code made by AB 860 pertain only to the November 3, 2020 general election, and Chapter 7 of the elections code added by SB 423 is only effective until January 1, 2021, and as of that date is repealed. Based on the history of special elections since 2008, it is very likely a special election will become necessary in early 2021. The governor continues to issue executive orders which create legislative policy. The evidence persuades the court it is reasonably probable the governor will continue issuing executive orders which amend statutory law and create legislative policy under the purported authority of the CESA, violating the California Constitution and the rights of plaintiffs thereunder, and give rise to a multiplicity of judicial proceedings unless restrained by a permanent injunction. The court finds good cause to issue a permanent injunction consistent with the request set forth in paragraph 21 of plaintiff's complaint as follows. Just to keep it interesting, and because it's been a while since I've used it,
I'm going to my sexy voice. Gavin Newsom, in his official capacity as governor of the state of California, is enjoined and prohibited from exercising any power under the California Emergency Services Act, which amends, alters, or changes existing statutory law or make new statutory law or legislative policy.
That is right, Governor Newsom. There was a very good reason for the separation of the powers, and you are not right in violating that separation of the powers. Alright, jokes aside, there is a very good reason for which there is this wonderful thing called the separation of the powers, and there is no justification for breaching the separation of those powers even during the times of a pandemic. No man is an island unto himself, and no man is a king of a state. And with that said, it is November 3rd, 2020. It is the elections in the United States of America. What a time to be alive. I cannot wait to tomorrow to see what the news is from today. We will see, but if you are watching this today, November 3rd, 2020, get out there and vote, because as I like to say, you can't complain about the system unless you go and cast a vote, even if it is to waste your vote. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Patreon, Subscribestar, YouTube membership. We've got locals. Follow me on Rumble. We've got merch. More important than any of that, take care of yourselves. Check in on friends and family. Make sure everyone around you is doing well during these very stressful times. And now you know you vlog. Peace out.